oral argument in the biggest Second Amendment case that we've seen in over a decade just took place in the New York State Rifle and Pistol Association versus Bruen case. And as you know, if you follow this channel, this Bruen case is all about whether or not the Second Amendment extends to carrying a gun outside the home for self-defense. New York basically says it doesn't, and of course New York's carry regime, which is really a non-carry regime, is being challenged by plaintiffs, including the New York State Rifle and Pistol Association. Now I'm going to talk to you about what happened at oral argument, and I want to try to discuss it in a very detailed way and try to analyze it the way members of the United States Supreme Court Bar would do in looking at the kinds of questions and comments made by the there are 9 justices. I'm going to try to give you an inside view so that you can be informed, because there's going to be a lot written on this oral argument. A lot of it will be by, in my view, members of the mainstream media that either have a particular biased view against guns and against the Second Amendment, or perhaps they're unfamiliar with guns and the Second Amendment and Second Amendment litigation. So even if they try to get it right, well, there's no guarantee that they will, because they may not fully appreciate and understand what's going on during oral argument and what it might mean for your rights and my rights under the Second Amendment. So stay tuned. Hey folks, I'm Mark and welcome to the Four Boxes Diner. Before we dive into the details of the oral argument that just took place in the NYSERPA versus Bruen case, I want to give you some high-level, big takeaways as I see it about this case based on what happened at oral argument. Okay, to begin, and most importantly, for those of you who are only going to watch this video for 35 seconds or so, I'm going to cut to the chase. I am confident that the Second Amendment and the plaintiffs in this case are going to win this case, okay? I do believe that there are 5 or perhaps 6 or more votes in favor of the Second Amendment and the conclusion that the Second Amendment confers upon American citizens the right to carry a gun outside the home, okay? But there's still some really important questions. In addition to, of course, there's no guarantee on any of this. You never really know what happens until a court issues its decision. But to me, it's looking very good in favor of the gun rights plaintiffs, okay? But even if they win, there are still some very important things we must look for and basically root for, if you will, that we hope to see in that opinion, or those opinions, when the Supreme Court issues them somewhere between now and the end of June of 2022, which is the end of this Supreme Court term. Now, there are 5 things I want to talk about today that occurred during oral argument that I think is important that you appreciate and understand. Again, there's 5 things I want to talk about. There's a million different things that you could talk about if you were really geeky about the Second Amendment and the Supreme Court, but I think for the purposes of the ordinary gun owner that wants to understand the realities of what's going on with the Supreme Court and the Second Amendment, I think there are big 5 takeaways. Again, 5 takeaways that you need to be looking at based on this oral argument that occurred today, okay? All right, to begin, I want to talk about briefly how you listen to an oral argument before the United States Supreme Court. What you're listening for is indications based on the questions or the interactions between the justices and each other, or perhaps between the justices and the lawyers for the various parties, okay? You're looking for signals or indications about how the particular judge or key justices might decide the case, or how they're thinking about the case, to get an indication of how they're going to rule and the basis upon why they're going to, not only how they're going to rule, but why they're going to rule that way, which in some ways can be equally, if not more important, for future cases involving, among other things, the Second Amendment, okay? So for the purposes of this oral argument, let me tell you what I looked at very specifically, okay? I paid, and I was mostly interested in, okay, the 3 so-called middle-of-the-road justices, and those 3 justices are Chief Justice John Roberts, okay? And then it's the 2 newest justices, that's Justice Amy Coney Barrett and Justice Brett Kavanaugh. Those are the 3 justices I paid particular attention to, and that we in the gun community should be focused on about what are they going to do. And by the way, if you're in the sort of anti-gun community or the gun control lobby, you're looking at the same three justices as well. You're just sort of cheering for perhaps a different outcome, but you're really going to be looking at the same things that I'm talking about. In fact, the things that I'm talking about today are not only going to be of interest to the pro-gun space, but also to the anti-gun space, because I'm really flagging the issues that everyone's looking for. Although I think at the end of the day, I'm happy to report for the pro-gun space that I think the pro-gunners are going to win this case, and I think hopefully are going to win it in a grand style. Okay, so let's go back to the three justices I want to talk about, the so-called swing justices. That's Justice Roberts, that's Justice Coney Barrett, and that's Justice Brett Kavanaugh. Now, I say they are arguably in the middle position of the court, not because they're middle of the roaders or anything, but if you actually are doing your math. Remember, as I've talked about in other videos, to win a case before the Supreme Court, you need at least 5 votes. It's a math problem. You need 5 votes out of the 9 justices to win your case, right? It can be 5 or more, but you got to have 5 to win. All right? Now, so that means we have to figure out, do we have 5 justices that are going to vote in favor of the Second Amendment, or are there 5 or more justices that are going to vote against the Second Amendment, if you will? Let's talk about the so-called liberal justices that, in my view, are probably lost causes when it comes to Second Amendment rights. That's my guess. Okay? Those are 3 justices. That's Justice Stephen Breyer, that's Justice Elena Kagan, and that's Justice Sonia Sotomayor. These 3 justices, I am guessing, and by the way, their questions at oral argument today were consistent with the view that they're generally hostile to Second Amendment rights. You could tell in how they cross-examined the lawyer for the gun rights plaintiffs, Paul Clement, as to how they were approaching this case. So I feel pretty confident that Justice Sotomayor, Justice Kagan, and Justice Breyer are going to rule against the right to keep and bear arms and say there is no right to have a gun outside the home for self-defense in public or something along those lines. But basically, they're not going to rule in a robust way in favor of the right to keep and bear arms. That's my best guess, based not only on their track record, but what happened at oral argument. All right? Now, on the other side, on the so-called conservative side, or the originalist side, if you will, you have 3 justices that I think we can be pretty confident are probably going to write in a way that's favorable to the gun rights plaintiffs. Okay, and favorable to a robust, broad view of the Second Amendment. And those 3 justices are, you've heard it before in other videos on this channel, that's Clarence Thomas, Justice Clarence Thomas, it's Justice Sam Alito, and it's Justice Neil Gorsuch. Okay? Now, these 3 judges, I would say, or justices, are most likely to vote to reject this New York law and to strike it down as unconstitutional. Okay? So now I've just lined it up. We have the 3 liberal justices, Sotomayor, Kagan, and Breyer. We have the so-called conservative or originalist judges in the form of Thomas, Gorsuch, and Alito. So what about, so that's 3 votes on each side if you're doing the math. So the question is, where do the other 2 votes come from if you're seeking more gun rights? Where did the other 2 rights come from, or the 2 votes come from? Well, let's take a look at what happened at oral argument to see what indications we have from the 3 so-called swing justices. That's Justice John Roberts, Kavanaugh, and Justice Amy Coney Barrett. Okay? Well, the good news is, and I think this is huge news, is that all 3 of them actually signaled very promising signs in favor of gun rights and the Second Amendment. All 3 of them did, and that's huge news as I see it for the Second Amendment community. Specifically, Justice Roberts, Justice Kavanaugh, and Justice Amy Coney Barrett, none of them, and this is key, none of them expressed any kind of suggestion or support for the notion of changing the standard of review for how courts measure when a law violates the Second Amendment. They seem to suggest that the standard of review, the criteria, the standard, the threshold, whatever you want to call it, for measuring whether or not a law violates the Second Amendment should be the same as it was in the Heller decision. And if you recall in Heller, the gun rights plaintiffs won that case on the grounds that the D.C. gun ban violated the Second Amendment, and it seems to be that the 3 so-called swing votes were in favor of the Heller standard, which is great for gun owners in America, in my view. Back in 2008, I want to remind you all that in the case of District of Columbia versus Heller, the Supreme Court struck down the district's handgun ban after the court conducted a contextual, basically reading the Second Amendment's text, and a historical analysis of the Second Amendment. And that decision in Heller set a very clear standard of review. Again, a criteria or standard by which you can measure if a law violates the Second Amendment. And that standard showed that the constitutionality of gun laws under the Second Amendment turns on a test called the text, history, and tradition of the Second Amendment test. I repeat, that's the text, the history, and the tradition of the Second Amendment and gun rights test is what Heller applied in 2008 by the Supreme Court. And basically they focus on the time of the founding to apply this text, history, and tradition test. You may ask, why does this channel, why do I produce so many videos talking about early American history? And I do that because a lot of that is exactly the same sort of history that the United States Supreme Court right now is analyzing and thinking about and trying to understand in connection with your right to keep and bear arms. And that's why I'm trying to educate the people on this channel on these topics, because it's the same thing, again, that the Supreme Court is looking at as we speak in the Bruen case. Now, I'm talking about the standard review, and I know it's a little geeky, maybe a little nerdy, maybe even a little boring, and the truth is, it's all kind of true, okay? But it's still extremely important for whether or not you have a constitutional right to keep and bear arms in America. This is one of these sort of things that actually is extremely important, and people may not fully appreciate it unless you're actually involved with the Supreme Court and the court system. And here's why. You see, ever since 2008, in the Heller case, the anti-gun lobby, right? A lot of people in the anti-gun space, a lot of the anti-gun lawyers, many of whom are excellent and highly qualified and very smart, they have been working very hard to push for a new standard of review or a new criteria for how you assess and review Second Amendment cases and whether or not a gun control law violates the Second Amendment. Most notably, and I did a video on this called Tiers of Scrutiny elsewhere on this channel, okay? Most notably, the sort of the anti-gunners, if you will, have mostly been arguing for a balancing test, okay? An interest balancing test of some sort, often called tiers of scrutiny in legal parlance. You see, this is really important because the anti-gunners, as a general matter, are arguing and are insisting that the interest in promoting public safety through gun control laws justifies the various states' restrictive public carry laws, okay? That's what they're arguing. They're saying that, yeah, maybe a gun control law violates the Second Amendment, but it doesn't matter because the benefits associated with that law are so great, right, that it outweighs the violation of any one person's right to carry a gun outside the home. So that's why a balancing test is terrible news for the gun rights community. You don't want any part of a balancing test. And that's why at oral argument in Bruen, it was so good, such good news, potentially, that Justice Roberts, Justice Barrett, and Justice Kavanaugh simply were not buying into any suggestion that any kind of an interest balancing test is appropriate for Second Amendment cases. In fact, if you look at what happened at oral argument, Chief Justice John Roberts actually questioned why on earth would the Supreme Court want to reinvent the wheel? Those were his words, not mine. Why would we want to reinvent the wheel after Heller? Just go back to Heller, look at the analysis, and apply to whether you have a right to carry a gun outside the home. That was, I think, great indication that even John Roberts, the Chief Justice, is good chance he's going to vote in favor of gun rights in this case. Of course, we don't know for sure, but it looks promising based on how he handled himself at oral argument, in this case. Now, Justice Amy Coney Barrett, the newest member of the Supreme Court who replaced Ruth Bader Ginsburg, she actually, in her questioning of the lawyer for the state of New York, actually got the lawyer to basically concede that the Heller case, which is very good for gun owners and gun rights advocates, that the Heller case was correctly decided. And the framework, text, history, and tradition, was really the right one to assess Second Amendment cases. And Justice Brett Kavanaugh, the other most recent confirmation of the Supreme Court, Brett Kavanaugh suggested that the text of the Constitution, right? He actually went to the text. In fact, it's like some of the commentators on the channel here, right? Justice Kavanaugh went to the text of the Second Amendment and asked the lawyer basically like, well, hey, let's look at the text of the Second Amendment, what it says. And of course, there's no doubt when you read the text of the Second Amendment, it has a very clear protection of the right to bear arms, not just to keep arms, but to bear arms. And it seemed almost like Brett Kavanaugh's view was, well, that seems like that kind of resolves the case now, kind of doesn't it? And I think that was, again, a good indication from Justice Kavanaugh that there's a good chance he's going to reject interest balancing and he's going to embrace, again, the Heller case. Now, I'm not super surprised that Justice Kavanaugh would be embracing text, history, and tradition over any kind of interest balancing, and why is that? You see, before he was on the Supreme Court, Brett Kavanaugh was on the D.C. Circuit Court of Appeals, okay? And when he was on the D.C. Circuit Court of Appeals in a case called Heller 2, right, which got a lot of discussion during Kavanaugh's confirmation hearing. During that case of Heller 2, which dealt with an assault weapon ban by the District of Columbia, Brett Kavanaugh dissented on a ruling that upheld that law, and Brett Kavanaugh basically wrote in his dissent that under the text and history and tradition of the Second Amendment, an assault weapon ban is unconstitutional under the Second Amendment. By the way, I would agree entirely with Justice Kavanaugh on that analysis. But really, Brett Kavanaugh, during oral argument, seemed to say he was kind of picking up where he left off in that Heller 2 case when he was a lower court judge, and seemed to indicate that he was going to continue that framework again, which is very good for the Second Amendment community. Now, I also want to say something notably about the Solicitor General lawyer, who I've talked about in other videos being excellent, and he was excellent. The lawyer for the SG's office was excellent, and arguing in favor of the New York gun control laws. But although his presentation was very good, he basically had no choice, I think, to kind of concede that the U.S. government mostly agrees with the approach that Kavanaugh laid out in that Heller 2 case of text, of history, and tradition, which I think, again, is very good news for gun owners and the gun rights movement in the United States. And again, I should mention, although the Solicitor General's lawyer did a great job in his presentation, in my opinion, I suspect he's going to be on the losing end of this case because, again, I think there's 5, perhaps even 6 justices are going to rule in favor of the gun rights plaintiffs, is my guess, based on what I saw at oral argument today and what I've seen on these justices' track records. Now, here's a second key takeaway from the oral argument in the Bruen case. You see, while everyone in the courtroom, as best I could tell, agreed that history is the key under the Heller analysis, the oral argument itself featured surprisingly little discussion about the particulars of the founding era record, again, 1791, when the Second Amendment was ratified. Now, there was some debate about the nature of the historical record, but the more consequential debate seems to be over which history, I repeat, which history is relevant. And by that I mean the relevant time period for examining the relevant part of United States history and United States traditions involving gun rights and the Second Amendment. Now, the United States government pressed hard the justices to extend the analysis of text, history, and tradition all the way into the late 19th century and even into the 20th century. And that would include, for example, the 1911 Sullivan Law in New York, which is actually what's being challenged in the Bruen case itself. Now, from a gun rights point of view, the author of the McDonald case, which was very good for Second Amendment supporters, it said that the right to keep and bear arms extends against the states. That's Justice Sam Alito, who's been a very good proponent for Second Amendment rights on the court. Justice Alito pushed back on this argument against the United States government, and Justice Alito asked how on earth could 20th century laws tell us anything about what the Second Amendment meant as an originalist matter, which of course is the standard Heller established, because the 20th century is, 100 plus years away from 1791, when the Second Amendment was, created and ratified. Now, this is a very important issue to look at or look for when the court issues its opinion. Because if in this decision in the Bruen case, the court focuses on its understanding of what the Second Amendment meant in the year 1791, again, when the Second Amendment was ratified, this will be very good, in my opinion, for the gun rights community, because if you look at the year of 1791, there was virtually no real gun regulations on carrying guns outside the home. And again, if the court embraces that time period of 1791, there really weren't a lot of gun regulations almost at all in 1791. So that's a very good time period for the gun rights community. It gets much worse when you get after the Civil War. You start to see more and more sort of gun restrictions for various reasons, which we can talk about in other videos. But the bottom line is, you really, if you support the Second Amendment, want the court to focus on that late 18th century, 1791, up until, I call it, July 4th of 1826, when Jefferson and Adams both die on the 50th anniversary of the signing of the Declaration of Independence. You do not want the court focusing on things that occurred after the Civil War as a general matter, because you start to see more and more modern gun control laws, and you don't want those to be part of the text, the history, or the tradition of our Second Amendment, because it's going to increase the chances of gun rights cases failing, okay? And again, all of this is because in the late 19th and 20th century, you start to see more states and localities in certain instances adopting an erroneous view that the Second Amendment somehow protects a collective right, which is really an absurd notion, a collective right and not an individual right. And then again, you start to see more gun control laws arising out of that assumption. Okay, now there's a huge third topic that was discussed at the oral argument, and it's actually not necessarily a great topic for the gun rights space. It's a dangerous topic, in fact, for the gun rights space, because it has the danger associated with the possibility of an exception swallowing the rule. And what was discussed, and this is the third big topic, was so-called sensitive places or gun-free zones, okay? You see, the term sensitive place was not my phrase or your phrase. It was a phrase that was used in the Heller case. And in one paragraph in the Heller decision, it basically seemed to suggest that restrictions on carrying guns in so-called sensitive places were constitutionally allowed under the Second Amendment. Now, the only examples that the Heller opinion gave of sensitive places were schools and government buildings. However, and this is something we got to watch real carefully, because this could actually hurt the right to keep and bear arms if it comes out in a kind of a bad way. And I don't think it's going to come out in a terrible way in the Bruen case, but we got to watch this very carefully now and in the future. You see, during the oral argument, all the justices seem to be sort of on board with the general concept that there are so-called sensitive places where a government could ban guns being there. But of course, at the end of the day, the devil's in the details. So several of the justices bombarded the plaintiff's lawyer, or the gun rights lawyers, the NYSERPA lawyer, Paul Clement, who's an excellent attorney, okay? They bombarded Paul Clement with various arguments and questions about what exactly qualifies as a sensitive place. Okay, they asked him about university campuses. They asked him about places where alcohol is served, presumably bars. They asked about, the New York City subway system. They asked about a football stadium. Are those sensitive places where you can ban guns? But at the end of the day, as Justice Kavanaugh pointed out, and this is, I think, is really probably what's going to happen in this opinion, although we got to watch carefully. We got to watch very carefully. But as Justice Kavanaugh pointed out in one of his questions, he basically said that, hey, isn't it a fact that the Supreme Court right now in the Bruen case is not obligated and does not have to actually resolve the precise contours or lines of what is a sensitive place and what is not a sensitive place, or even get into that in any great detail, because the plaintiffs or the petitioners in the Bruen case are only challenging the fact that they were denied the right to carry a gun in the state of New York because they were denied a license allowing them to carry that gun in New York for self-defensive purposes. They're not challenging any of the various restrictions on where, I repeat, where people with gun licenses can carry in the state of New York. And that is why Paul Clement, as best I could tell, looking at the argument, it's why Attorney Clement mostly kind of deferred in answering specifically whether certain locations should or should not be considered sensitive. And again, I don't think it's a given that the justices are going to accept Kavanaugh's position, and that's why, again, I think a key thing that we all should be looking at in the Bruen decision when it comes out between now and June of 2022, we really need to see exactly what they say, if anything, about this so-called gun-free zone exception or sensitive places exception to where you can carry your guns, because if they make a big exception, it's possible that sort of the anti-gun community and legislatures could use that as a way to use an exception to swallow the rule of you being allowed to carry a gun outside the home in public. And let's just think of like a crazy law that could be passed that would be very very problematic for people that carry guns for self-defense in public, and that is, let's say a state or a city or someone passed a law that restricted the carry within 1,000 feet of any school, church, park, or government building. Well, again, it'd be very hard, practically speaking, to find a path for carrying in a city like that if that law were to become the law of the land and upheld under the Constitution. Now, the fourth big topic that was discussed at oral argument in the Bruen case, the fourth big topic was the notion of public safety. This is a huge argument, and then, of course, public safety is often something that the anti-gun community or those that like gun control laws really push hard, and they did so at this oral argument. You see, here's why. If the court talks about public safety as a standard for whether or not you get to carry a gun in public, then it means basically the court's going to ignore the text, the history, and the tradition standard review, which again, as I've explained before, is very bad for gun owners because that text, history, and tradition standard laid out in the Heller decision is very good for gun owners because it looks at 1791 when there really were no gun control laws. But if the court embraces an interest balancing test, you're really giving too much discretion to judges to basically uphold gun control laws in the name of public safety, even if those laws violate your Second Amendment rights. So we don't like that if you like the idea of being able to have a gun for self-defense outside the home in public. Now, I will say that the attorney for New York, Barbara Underwood, who made the argument, she repeatedly stressed, and I think she did a good job hammering home her points to the court. She stressed the need to keep guns off the street, as she saw it, of densely populated areas, kind of a metaphor she was using for cities, presumably. Now, the state of New York expressed less concern for carry in the more rural areas of America, but Justice Thomas asked a great question, which is, well, how do you define rural, and how do you know when something's rural versus urban? I think that was a great question by Justice Thomas at the argument. Now, again, I will let you know that the New York attorney got a lot of pushback when she tried to make this distinction between urban areas or heavily densely populated areas and rural or less densely populated areas. And in what I would consider one of the funniest or the most memorable lines at oral argument, Chief Justice Roberts actually asked the lawyer for New York, well, how many muggings take place in a forest? Right, suggesting that the need for self-defense is actually more important in high crime or urban areas or concentrated areas, more populous areas, than perhaps in many rural areas. And I think Justice Alito, to his credit, he had a great question that I think really came across as very pro-Second Amendment. You see, Justice Alito, who's from New Jersey, by the way, he was a judge in New Jersey before becoming a Supreme Court justice. Justice Alito is familiar with the New Jersey-New York borderlands because of where he's from. So he really knows how that New York world works. And Justice Alito at the oral argument in Bruen, asked a great question. Specifically, he said, well, what would happen, if you have a person, working to clean late at night one of those big, office tower buildings in New York City, and they left that building after work, and they had to walk to the subway, and then they got on the subway, and they took them home, and then they had to get off the subway, then they had to walk through kind of a crime-ridden neighborhood to get to their house. How come they can't have a gun to carry with them to protect them, against criminals? I thought it was a great question from Justice Alito, and there wasn't really a good answer from New York, as I saw it, to push back on that. Because his view is, well, don't they need self-defense, and don't they have every right, as much right of self-defense as any celebrity or politician or judge does in the state of New York? And I think Justice Sam Alito did a great job with that. And I should also add that Justice Kavanaugh, again, one of these so-called swing votes, and again, I think this is very good news for the Second Amendment community, Justice Kavanaugh asked at oral argument, what evidence was there that moving a state from a may issue or restrictive gun permitting regime, right? Again, a may issue law gives the government discretion to issue a license or permit or not. It's up to them. It's up to the government official. They decide whether or not you need the gun, right? And again, as I've written about and talked about, it's kind of like, do you have a right to go to mass? Well, only if under this theory, only if you really, really need to pray for something, then the government would let you go to mass or would let you go to church. Of course, that's kind of absurd. That's not how the Constitution works. And Justice Kavanaugh, to his credit, kind of alluded to this because he basically said, so what evidence is there in New York that moving a state from a may issue jurisdiction to a may issue law to a shall issue law leads to significant public safety problems? Because he says, I don't really see it. And again, Kavanaugh really hit the nail on the head when he says he hasn't seen evidence that going to a shall issue regime of issuing carry permits caused any kind of major crime or increase in crime or anything. And again, none of this even matters if the court adopts a text, history, and tradition approach or standard, because at that point the public safety arguments or balancing tests become entirely irrelevant. But if the Supreme Court decide to apply a tiers of scrutiny or standard of review with some sort of interest balancing test, then public safety will be a big deal. And it seems like Brett Kavanaugh, at least from his questions, as well as the questions from Justice Roberts and Alito, seem to think that the public safety argument doesn't necessarily cut in favor of the government. It may very well cut in favor of the individual law-abiding gun owner. Okay, here's the last big question at stake in the Bruen case based upon the oral argument, the fifth and another big one. And that is the Second Amendment a normal constitutional right? Now, this is like a stupid, absurd question in certain respects, but it's not, because they're actually talking about it at the Supreme Court, and New York basically kind of says, no, it's not. So again, the question is the Second Amendment like any other constitutional right or not? Okay, you see, this entire question laid under the entire oral argument in the Bruen case. You see, because New York argued that the right to bear arms may be in the Constitution. It may appear in the Bill of Rights, yeah, but the truth is it can apply differently in the city versus the countryside, and basically says that in the context of the Second Amendment and gun control laws, the government should historically and should be allowed great discretion to decide how the Second Amendment applies and who gets to enjoy the exercise of that right. In fact, Justice Kagan, who, as a reminder, is one of those justices that I consider kind of liberal and anti-gun, you're never going to win her over as I see it. Even Justice Kagan seemed to indicate that New York's arguments is not really typically how we treat constitutional rights. In other words, again, Kagan, even the liberal Kagan, is kind of saying to New York, geez, if it's in the Constitution or Bill of Rights, we respect it, and we don't really go to some local politician or local official and let them decide, do you have the right to the constitutional right or not? That's not really how it works. We don't say mother may I to local officials when it comes to constitutional rights. And even Justice Kagan was kind of taking that view, which I take it as a very good sign for the Second Amendment community. Now, beyond Justice Kagan, who I still think is going to vote against the gun rights, I think it's unlikely she's going to vote in favor of gun rights. She's going to vote for gun control and in favor of New York is my guess. But let's take a look at what happened with Chief Justice Roberts, another one of these swing justices. Justice Roberts stressed how it's highly unusual to limit licenses to exercise a constitutional right only to a handful of citizens, to a subset of citizens whose circumstances are deemed important enough to allow those few people to exercise that constitutional right, or in this case, a constitutional right to carry a gun, right? It's kind of odd that usually the Constitution applies to everyone. Everyone has a constitutional right. And Justice Roberts is kind of like, well, why is the Second Amendment in New York only applying to like a handful of people? Why shouldn't it apply to all the people? And why should these people have to go to a local official and beg and plead to be able to carry a gun under the Second Amendment? So even Roberts is like, this seems like not how we usually do things under the Constitution, right? And again, another swing vote, Justice Kavanaugh, he also appeared to think that the discretion, which basically means that the person who issues the carry license has the discretion to decide, do you get it or you not? And Justice Kavanaugh appeared to think that the discretion vested in the licensing officials made matters even worse. Now, New York did have arguments against this. I mean, New York's principal argument at oral argument to these arguments about the discretion was that historically and otherwise, the Second Amendment is different from other constitutional rights. That's what they basically were arguing. The state of New York, they said that it's a different kind of because it involves deadly force, it involves a different kind of constitutional right than the rest, okay? I don't agree with it, but that was their argument. So this, again, is another key issue to watch for in the Bruen decision when it comes out between now and June of 2022. Because if the court makes clear that the Second Amendment is to be given the same degree of respect and protection as other constitutional rights, that will be a great victory for those that support the Second Amendment. Now, of course, I want to put this caveat in this video, right? Given the number of variables in play, there is a massive number and a wide range of possible outcomes in Bruen as to who's going to win this case, and most importantly, if not more importantly, what will the opinion actually say? Will there be multiple opinions? Will there be dissents? Will there be concurrences? Okay, we just don't know. But here's a couple ways to think about it. You know, at one extreme, it's possible that the Supreme Court could hold that the standard of review, let's say the tiers of scrutiny analysis, applies, and that more evidence is needed in the lower courts to determine whether New York can justify denying licenses to the plaintiffs to challenge in this case. Basically, send the case back for more evidence before they decide whether or not there was a violation of the Second Amendment. That's one possible outcome, which I think would not be good for the gun rights community. Now, more of a middle possibility of what the court might do here is that the court might hold or find that the plaintiffs in this case, I think their names are Nash and Koch, that the plaintiffs here have a right to carry guns based on the fact that their residence is in upstate New York, and there's really no compelling argument in favor of limiting carry in upstate New York far, far away from the urban area of New York City. That's a possibility, but then the court could still reserve judgment on questions about broader contours of the Second Amendment. In other words, they could rule for these two particular plaintiffs and really not set broader guidance for other future plaintiffs, in the decision they wrote. Now, as I see it from a gun rights perspective, the best case scenario for the gun rights perspective is that the court could hold and find that the text and the founding era history around 1791 in American life was dispositive and is dispositive, and that the New York gun control law flunks this text, history, and tradition test, and that as a consequence, ordinary law-abiding citizens, including in the state of New York, must be allowed the right to carry firearms for self-defense in public. Okay? Now I know there's a lot we talked about today. I hope you learned a little bit something about this, but at the end of the day, we're all going to be eagerly awaiting a decision in this case, which again will come sometime between now and the end of June of 2022. Okay, well, thanks for tuning in to a very long edition of the Four Boxes Diner, where we like to serve hot, fresh Second Amendment news and analysis. And if you like what you heard, please subscribe and spread the word. And again, we'll see you next time here at the Four Boxes Diner.
Orders up. Table 2A.